Hello everyone, coming back to the second session titled The Impact of Local Law Facilitation on Seat Selection in Arbitration Proceedings. This session is co-hosted with Thailand Arbitration Center or THAC. This session will run for 1 hour from 11 a.m. to 12. I will now pass the session to Mr. Nicolas Tang from Farallon Law Corporation, who will be a moderator of this session.
Thank you. Good morning, everyone. I'm pleased today to introduce our distinguished panel of experienced arbitrators, counsel, and lawyers to discuss the impact of local court facilitation on seat selection in arbitration proceedings. And today it's very interesting because we have representatives from 4 different jurisdictions. That would be Singapore, Hong Kong, Indonesia, and finally Thailand. So it gives me great pleasure to introduce our speakers today. The first speaker will be Christopher Chong. He's the head of, he's on the far left there, he's the head of construction and engineering director and in dispute resolution in Drew and Napier in Singapore. Chris is highly experienced Singapore qualified dispute resolution lawyer with extensive experience in commercial disputes, particularly in banking, construction, and natural resources. Over the past 2 decades, he has established a strong reputation for successfully representing high net worth individuals, including in significant cases such as a US $250 million claim against an international bank. He has acted as lead counsel at all levels of the Singapore courts and in both international and domestic arbitrations. Chris is a senior accredited specialist in building and construction by the Singapore Academy of Law. He has handled over 100 adjudications, including some of the largest in Singapore, and is a recognized adjudicator and editor for the Singapore Construction Adjudication Review. Chris also represents resource owners and traders in international mining and commodity disputes. The next speaker I'd like to introduce you to is Mr. Joseph Chung, a partner at Deacons from Hong Kong. Joseph specializes in litigation and dispute resolution with particular emphasis on construction law. He was previously a barrister until he became a solicitor in 2001, 23 years ago. Joseph has extensive experience in all aspects of construction in both private and public sector work, advising developers, contractors, and consultants. Joseph also has experience in conducting THAC arbitrations in China and Hong Kong, and Joseph has been granted higher rights of audience in civil proceedings before the High Courts and Court of Final Appeal in Hong Kong, and is only one of a small number of solicitor advocates in Hong Kong. The third speaker today, who is on my right, will be Nico Angelo Putra Mooduto. He's from SSEK, a prestigious law firm in Indonesia. He joined the law firm in 2011, about 13 years ago, and his practice covers a wide variety of commercial legal matters and both inbound and outbound work. Nico has advised and represented many prestigious multinational corporations, including Microsoft, PepsiCo, General Electric, Rolls-Royce, General Motors, Nissan, Boeing, and FedEx. Nico also advises on various greenfield and brownfield investment projects in Indonesia. The fourth speaker we have today would be none other than Noppramart, Thammateeradaycho. She's a seasoned litigator with over 20 years of experience in trial and appellate advocacy across all levels of Thai courts, as well as international litigation and arbitration in countries like Singapore, Australia, Cambodia, Myanmar, and Laos. She is highly regarded for expertise in arbitration, adeptly handling cases under both international arbitration, UNCITRAL, SSEK, ICC, HKIAC, GAFTA, and domestic arbitration rules like BANI, NCAC, TAI, THAC. Her practice spans various industries including construction, insurance, telecommunications, and media. Noppramart is particularly distinguished in the transportation and shipping sectors, representing P&I clubs, ship owners and insurers in disputes involving cargo claims, marine insurance, ship arrests, and more. She has handled complex maritime litigation and is known for ability to provide quick and effective solutions in urgent cases. Noppramart currently serves on the arbitration panels of several institutions, including the Thailand Arbitration Center and ICC, and holds key roles in Thailand's arbitration community. So without further ado, we will start with our first speaker, Chris. Chris, can you start off and explain to us your perspective from Singapore?
Of course. Thanks, Nicolas, for the introductions. Before I start, I would like to thank the THAC first for this opportunity to share the Singapore perspective, as well as Tilleke and Gibbins for hosting this in this rather impressive auditorium for a law firm. Not many law firms in Singapore will have an auditorium of this size. Let me get my set of slides on the screen. That will hopefully speed things up. Now, I think it's fair for me to say that it is widely recognized in the arbitration world that Singapore, it's a popular seat in terms of being an arbitral seat. Now, I share some statistics which I managed to obtain from Queen Mary University of London. And unfortunately, it's 2021, but it's the most recent set of statistics that I can find. And if you look at the numbers right at the bottom and the chart at the bottom, you see Singapore as, I think, the leading seat in Asia Pacific, though I must say Hong Kong is really just a little bit behind. So I consider us neck to neck for all intents and purposes. And internationally, between Hong Kong and Singapore, we are rather close to London, frankly, as the seat of choice worldwide. Now, there are number of reasons, and I think these are the commonly accepted reasons as to why Singapore is a popular choice. You see them on screen. We have arbitration-friendly laws. We have got an International Arbitration Act. The model law, ancestral model law, forms part of Singapore law, except for some minor exceptions in the International Arbitration Act. We have got arbitration-friendly courts, and that is what we are going to discuss later, and I'm going to elaborate on that. We are a relatively neutral venue. We try to be everybody's friend in Singapore, so I think that helps. And we have got strong global positioning. We are regional or global HQ for many companies. We are the aviation central sort of place where we've got good flights coming in and out. We have got good arbitration infrastructure. Lots of international law firms have got a presence in Singapore, including a strong arbitration practice for most of them. For those who have arbitrated in Singapore, you might have been to Maxwell Chambers, which is a fantastic set of facilities for conducting arbitration hearings. Now, but for me, I think the most important really it's the fact that we have got a good arbitration-friendly courts. And what I've done in this slide is to show you that as part of that Queen Mary University survey, what they have asked arbitration users is, what would you like most seats to change, to improve, in order for you to change your seat of choice to somewhere else? And if you look at the first three bars right at the top, they all have something to do with the local courts and how they support arbitration, how they enforce awards, and how they support the arbitration process. Now, what has, in my view, Singapore done right? Now, what I've done is I've quoted Justice Judy Prakash at the SIAC Center Symposium 2023, where I think she hit the nail on the head. And I think she's right to say that what I think we have done right is we have provided clarity on a number of issues which affects arbitrations that are Singapore-seated. And what the courts have done is they have tried to provide this clarity on a series of issues, some of which we'll look at today. And why is this important? I think you come right down to it. Arbitration concerns mostly commercial contracts and commercial disputes. And commercial parties tend to like some level of transparency, some level of predictability and clarity on issues, because it allows them to manage their risk. And I think that's where I think we do relatively well. Now, I'm going to quickly run through some reported decisions on these four issues, which I think are important and has helped us propel ourselves to the top in terms of being a choice for arbitration seat. Now, and let me start with the first area, which is the boundaries of arbitration. Now, I've got a case there, BBA and BAS. In case you're wondering, that's not the real name of parties. because arbitration, it's mostly confidential in nature, and Singapore courts, they tend to try to respect that confidentiality. So what they do in reported decisions is they redact the name to put in BBA, BAS or something else. So we keep the parties confidential. Now, this case, I'm going to start with just a few facts. Now, the dispute arose from a sale and purchase of a block of shares. The buyers commenced arbitration against the seller for, I think, amongst other things, misrepresentation. The seller raised a number of arguments, one of which was that the buyer's claim was time-barred. Now, the time-bar argument was rejected by the tribunal. The seller, when they lost the arbitration, went on to try to set aside the award in the Singapore courts and argued that the tribunal has no jurisdiction to determine time-barred claims. Now, what the Singapore Court of Appeal did was, when they considered a jurisdictional argument, it's to apply what they call the tribunal versus claim test. Actually, I don't think we invented this. I think it was already pre-existing in a number of Commonwealth jurisdictions. And what this test asked was whether the objection was targeted at the tribunal in the sense that the claim could not be arbitrated or should not be arbitrated due to a defect in or omission to consent to arbitration, or at the claim itself, in that the claim was defective and should not be raised at all. Now, the difference is this. If the objection is targeted at the tribunal, there is a jurisdictional objection which the Singapore courts will hear de novo to determine whether there's any basis to that. But if the objection is vis-a-vis the claim, that's an issue that's squarely within the arbitrator's jurisdiction. Singapore courts will not interfere. Now, in this case, the Singapore Court of Appeal found that a time-bar objection is an admissibility issue, not a jurisdictional issue, and they didn't set aside the award on that basis, even assuming that there was some basis to the objection. Now, what this has effectively done is to narrow the sort of jurisdictional argument a dissatisfied party can raise in a set of setting aside proceedings that they're in the Singapore courts. And that's more or less consistent with, I think, the minimal intervention the Singapore courts try to have in relation to arbitrations in Singapore. Now, the second case, I can quickly run through it. The facts are not important. Now, but if you read what I've set out extracted from the judgment, this case reaffirms Singapore's consistent refusal to allow a backdoor appeal in the form of a setting aside application. You know, you may be a dissatisfied party, but if what you're unhappy with, it's a decision on a legal issue or a factual issue, that's not what the Singapore courts are prepared to interfere to overturn the arbitration ruling. Now, the second area, interim orders. Now, this is something different, and what I can say is the Singapore courts, they do grant interim orders in support of arbitration. They consistently do that. But the objective is to support arbitration. It is not to supplant the tribunal or an arbitrator. So there are some boundaries within which interim orders will be granted. Now, the Singapore courts will assist if it's urgent, or if there's permission from the tribunal, or if both parties agree, but not if these requirements have not been met. And if the interim order can be overridden by a tribunal's decision subsequently as well. The whole idea is, as far as the courts are concerned, vis-a-vis interim orders, the objective is to assist and not to replace the tribunal. Now, the third area I want to discuss is the setting aside of arbitral awards, and we subscribe to minimum career intervention in Singapore. And what I've done in this slide is to provide 2 paragraphs from a 3-year-old decision in the Court of Appeal in Singapore. And I think this is worth reading out because it really summarizes the arbitration regime in Singapore and the court's participation in it. Now, under Singapore law, the scope for judicial intervention in arbitral proceedings is narrowly circumscribed. In the context of applications to set aside awards, this is borne out by the fact that a party seeking to challenge an award may only do so on limited prescribed grounds, and this will be what's in the model law, plus I think 2 additional grounds which you have in the IAA. Now, even then, the court will exercise its power of restraint, setting aside awards when there's good reason to do so. This to strike a balance between minimal career intervention and to make sure that challenges of merit are properly ventilated. Now, the second paragraph, it's just to give you a sense in terms of success rate. The court in this case actually took a look at the previous decisions and came out with the statistic that approximately of 20% of setting aside applications actually succeed in Singapore. So it's 2 out of 10, not a very high number. But I think the challenge, not only for us, but for all jurisdictions, is to find a balance. I mean, the whole concept of arbitration is we want minimal court intervention. But at the same time, minimal doesn't mean zero. I think it's still useful to have somebody supervise the process to make sure that there's due process, to make sure that there's some fairness in the way arbitration is being conducted. Now, this decision, CNQ and CNR, again, I don't think the facts are relevant, but if you look at the first paragraph I extracted from the judgment, it gives you a sense of how the courts approach a setting aside application vis-a-vis an award. Now, the idea and the objective is to support, it is to uphold the award rather than to destroy it. And there's a great temptation, I can tell you, in setting aside an application in Singapore to really comb through the award paragraph by paragraph. And when you have a 400-page award, you can imagine the resistance to that by some of the judges. Now, so the court doesn't want to comb the award microscopically. They want basically to look at it holistically to determine whether the award was, the arbitration was conducted in a fair manner and the like. Now, the second paragraph is to give you a sense of the court's expectation of arbitrators in Singapore. Now, so what the court will look at is what a reasonable and fair-minded tribunal in those circumstances might have done. I mean, I think we recognize that no arbitrator is going to be perfect, no arbitration is going to be perfect, but holistically was what the arbitrator did in a specific arbitration, was it reasonable? I think that's the approach. And there's an expectation as well that if you want to make an allegation of breach of natural justice, the tribunal should be given an opportunity to deal with that rather than to raise it in the setting aside application. Now, I think I can skip this. The fourth area I want to deal with, it's on the enforcement of arbitral awards. Now, so there are two schools of thought. One school of thought takes the view that enforcement should be more or less mechanical. So if you subscribe to the New York Convention, most jurisdictions will enforce awards as a matter of course if you subscribe to the convention. Now, but in this case, I think what the Singapore courts have shown is they're also prepared to be flexible rather than take a fully mechanical approach. And now, I think I need to expand on a little bit of facts because it's going to be a bit difficult to understand. So Keppel commenced arbitration against Hydrolift. Hydrolift had a counterclaim. Now, but by the time of the arbitration, Hydrolift did not actually exist as an entity because they went through 2 mergers. And the entity was struck off, I think, the Norwegian Register of Companies. Now, what National Oilwell did was to defend that arbitration and to prosecute the counterclaim in Hydrolift's name. Now, nobody knew about that until, I think, enforcement, where Keppel raised an objection that because Hydrolift didn't exist and the award was granted in favor of Hydrolift, the award shouldn't be enforced. In fact, the arbitration and the award, they are both nullities. Now, what the Singapore court found was, as far as the Hydrolift was concerned, the legal personality of Hydrolift effectively merged into National Oilwell. So they were prepared to enforce the award in favor of National Oilwell, even though they were not a party to the arbitration. And what I think this helps is I think there's a certain degree of flexibility the Singapore courts have shown. And I think at the end of the day, the approach they have taken is to try to do what's fair and what's just. In this case, there's no real difference between National Oilwell and Hydrolift. And they're prepared to enforce the award even though it was not in National name. Now, that brings me to the end of this. I'm sure Joseph will have more to share.
Thank you very much, Chris, for your illuminating views on the Singapore court's attitude. I would now like to let the audience know that if you have questions for our speakers, let's leave it to the end after the 4 speakers have presented. And so I'd like to invite Joseph now to present his perspective from Hong Kong. Joseph?
Thank you, Nicolas. Let me it really, as Christopher said, a fantastic venue. Equally, I echo what Chris said. In Hong Kong, in a law firm, it really will be difficult to get even half the size of this venue into the space. So really, it's fantastic. It's a really beautiful venue. Really a great work to Tilleke on this. Fantastic. So it's really nice to see you all today. So you heard Christopher talking about the the Singapore perspective. So I will now move on to talk about the Hong Kong perspective. I'm sure many of you all know Hong Kong was previously a British colony. In 1997, the Chinese government resumed sovereignty over Hong Kong. And since then, Hong Kong has been working on the one country, two system model. So we have maintained the common law system. Now, under the arbitration regime, our statute is the Arbitration Ordinance. It is pretty much based on the uncitral model law. And the approach of the Hong Kong courts is to take a pro-arbitration stance, letting the parties to go ahead with arbitration and respecting the arbitration agreement. Now, Chris very nicely just now put up a slide on the Queen Mary survey. And he very humbly said that Hong Kong is on a neck-to-neck game with Singapore. But if you will see from the statistics, actually Hong Kong is 4% behind Singapore. But anyway, Hong Kong is also one of the leading seats of arbitration. Now, as Chris has shown on his slides, a couple of the main areas where it would affect an arbitrator uses thoughts and decision on whether or not to choose a place of arbitration would include the support for arbitration by local courts, the judicial independence, reputation for enforcing an arbitration agreement, and also an arbitral award. Now, I would like to cover these four areas, demonstrating how the Hong Kong courts work in this perspective in the time that I have. Now, as I said earlier on, Hong Kong really is sort of adopting an approach of a hands-off approach. You guys have agreed to arbitration, you sort it out in arbitration. But that said, as Chris said, is not a 0% thing, all right? Now, if there are circumstances that the courts need to step in, the courts will do so. Now, what sort of circumstances they would do so? I identified a couple of points there. Staying for court proceedings in favor of arbitration, ruling on challenges to appointment of arbitrators, granting interim measures, taking of evidence, setting aside arbitral awards, and enforcing arbitration awards. Now, I will focus in my discussion today on the four items highlighted. Now, generally, if parties have an arbitration agreement and one of the party, in breach of that arbitration agreement, decides to start court proceedings, the court's general approach is this: is there an arbitration agreement? If yes, the next question is, well, does the party dispute the debt, right? Does it say that I don't admit to it? Now, if that's the case, a very low threshold, then please go to arbitration. We will not allow these court proceedings to continue. You have to go to arbitration. But an interesting topic that has arisen, especially recently, is on a situation where if one of the parties to an arbitration agreement decides not to go to arbitration or court proceedings, but decides to wind up the other side, what would the courts do in this sort of situation? In other words, you have a petition debt that is covered by an arbitration agreement. How would the court handle it? Now, I think in the common law world, the general consensus is if there is a dispute, go to arbitration. But where the courts around the different common law jurisdictions have differed is what is the threshold, right? What is the hurdle that one has to overcome before going to arbitration? Now, there are two schools of thoughts. One school of thought is called the substantial dispute test, which is that the party will have to show that there is a substantial dispute before the company's court will say, okay, stop the winding up proceedings, go to arbitration. That's the substantial dispute. And there's another test, which is a lower level test, which is to say that, well, as long as this dispute is not frivolous, right, it is not an abusive process, go to arbitration. This is the lower threshold. Now, this difference between the two tests have been subject of much decision in Hong Kong. There has not been a consistent ruling as to which approach to adopt until recently in the case of Simplicity and Vogue Retailing in the Court of Appeal. Now, I'll just go one step back. Last year, in the Hong Kong Court of Final Appeal, so this is the highest court in Hong Kong. In the old days, before 1997, the highest appeal court would be going to the Privy Council, but since 1997, it is the Court of Final Appeal. Now, the Court of Final Appeal in the case of Guy Lam had looked at it in the perspective of an exclusive jurisdiction clause. And the court said that the proper approach is to adopt the lower threshold test. In other words, as long as it's not frivolous, as long as the claim is not an abusive process, go to arbitration. But what the court left open was the question of whether or not this applies to arbitration. So the fight continued until this very case of Simplicity and Vogue, whereby it held that this ruling, the applying of a lower threshold, applies also to arbitration. So since then, and a subsequent case, the threshold for deciding whether or not the liquidation proceeding should be stayed, which is simply to look at whether the dispute is an abusive process or is it a frivolous one. Very low threshold. But the thing doesn't stop there, because what's interesting was that a few months later in the UK, in the Privy Council, the same question was brought before the Privy Council from a BVI appeal. Now, the court looked at it from a different approach. Now, if I just go one step back, in the Hong Kong Court of Appeal, one of the reasons why they said that they should adopt a lower threshold test is because they said that Hong Kong is pro-arbitration. They should respect the parties' agreement to arbitrate. So as long as the dispute is not frivolous, the parties have to honor their agreement and go to arbitration. Now, in this Cyan and Halameda case, it took the same issue into consideration, this pro-arbitration argument. But they looked at it from a different perspective. They said that, well, if somebody was able to simply say that, well, as long as my claim is not frivolous, then it should go to arbitration, then you will have lots of these guys going to arbitration merely to delay matters. And this does the reputation of a pro-arbitration state no good. So they said that the applicable test is the substantial dispute test. So they went to the higher test, and they said this is the law that England should be following and should be the BVI. So now we have in the UK adopting the substantial dispute test, but we have Hong Kong adopting the lower test. Now, after the Cyan case, I understand that in Malaysia, they have followed the substantial dispute case. Now, Christopher, correct me if I'm wrong, I understand that in Singapore, they are following the lower threshold test. So it's interesting to see this, this divergence in views in terms of what is the applicable threshold in different common law jurisdictions. Insofar as Hong Kong is concerned, for the time being, it will be the lower threshold test. But if in the future there's another case that goes to the Court of Appeal or it goes to the Court of a Final Appeal, this debate will arise, given the fact of the ruling in the UK Privy Council. Now, I'll move on to look at challenges of arbitral award. I set out there Section 81 of the Arbitration Ordinance, which is modeled upon Article 34 of the Arbitral Model Law, the possible grounds of setting aside an arbitral award. As Christopher has highlighted earlier on just now, you can see that the real focus there is on procedure. Not about the merits. It's not about the merits at all, but whether or not there was due process and compliance with natural justice. Now, I thought I would share with you a recent case in Hong Kong. It has very interesting facts which demonstrates how the Hong Kong courts approach this issue of setting aside. Now, this is the case of Song Li Hua and Li Chi-hon. Now, this related to an arbitral award that Chong had obtained in mainland China. And what it sought to do was to have it enforced in Hong Kong. Now, in the course of doing so, he sought to have it set aside on many grounds, right? But I think what was interesting is the grounds of opportunity to present its case, a right to a fair hearing, and contrary to public policy. Now, this is where it gets interesting. The argument of not having a chance to present its case concentrated on the fact that there were a 3-member tribunal, 2 members were at the physical hearing, but 1 member attended it by virtual hearing. Now, first half of the hearing, it went fine. But second half of the hearing, because what happened was the judge actually looked back at the video recording, and that 3rd arbitrator was found to have leaving the venue. He was talking to various people. He went on a car, and then he went on a train, and then there was intermittent disruption in the connection, and then the chairman said, "Can you hear me? Can you hear me?" And there was no response, right? So it was against this sort of background. And so Lee said, well, I didn't have a chance to properly present my case, given the situation. And then what Chong said, hey, no. The fact was that in mainland China, you tried to set aside the award on this very same grounds that you weren't given a fair hearing. But the mainland courts said that whilst there was a defect, but it would not have affected the outcome of the award. So set aside, not allowed. What the judge said is, we've got to differentiate 2 situations. The first situation is where you're seeking to set aside the award where the seat of arbitration is. They have their own standards. The second situation is you're trying to enforce this award abroad. The courts abroad will have their own standards. And using the Hong Kong standards, the court clearly felt that there was a breach of natural justice. Not only must justice be done, but it must be seen to be done. And the court was saying here is that, well, if you were running around in the middle of a hearing, either you're telling me that you are not interested in the case, or 2, you have already made your decision. So the court said, out it goes, I will set it aside. So I think this case clearly demonstrates that the courts are prepared to step up in Hong Kong to set it aside, notwithstanding what other foreign courts could have decided in terms of whether or not to enforce the award, where it infringes on the principles in Hong Kong or whether or not the arbitral award should be set aside. So this comes to my last point on interim measures. I'll be quite quick on this. Generally, again, under Section 35 of the Arbitration Ordinance, which models on Article 17, sets out the arbitral tribunal's powers to award interim measures. Where this becomes interesting is that under Section 45, the courts actually have parallel powers to award interim measures. But it does state specifically the circumstances in which the court should consider to decline to award the interim measure, which will be interim measures sought is currently the subject of arbitral proceedings. Court considers it more appropriate for interim measures sought to be dealt with by the arbitral tribunal. So then I'm sure you all will be questioning is, well, when do I go to the courts? When do I go to the arbitral tribunal? Now, experience shows that if you haven't commenced an arbitration yet, then you can go to the courts. The courts will generally allow it. But where you already have arbitration proceedings on foot, then this is where it becomes tricky because it's more likely that the court will not grant you the interim measure and ask you to go back to the arbitral tribunal. Quite easy. You have an arbitration agreement, you have arbitration, get it sorted out in the arbitration. That's the court's approach. But of course, if you are seeking some reliefs that is beyond what you're seeking in the arbitration, then that's where the court will be able to sit. So that's it for my part of the presentation. So over to the civil law sides.
Thank you so much, Joseph, for sharing the Hong Kong perspective. It gives me great pleasure to now introduce Nico. If you could get Nico's slides on the screen, please.
Yes, thank you, Nicolas. Good afternoon, ladies and gentlemen. Thank you for your attendance. Echoing my colleagues from the common law jurisdictions, I would also like to extend my thanks and gratitude to THAC, to Noppramart, and Tilleke Gibbins, specifically for this opportunity. And my name is Nico Mooduto. As has been introduced by Nicolas, I'm an Indonesian lawyer, so I would be covering the Indonesian jurisdiction. Now, my presentation would consist mostly of basic understandings and concepts of the Indonesian arbitration regime. And I understand that there's not that many legal literature on Indonesian law. So I thought that it would be helpful just to cover the basics, if you will. And so hopefully it would be helpful for you, ladies and gentlemen, as well, not too boring, hopefully. So with that, I have my slide. Just a little introduction on Indonesia. I'd like to be somewhat of a brand ambassador when I speak in foreign conferences. Indonesia is a country of 280 million people. We're the world's fourth populous country in the world. We have a steady GDP growth. We are a G20 country. An interesting recent development is that we are in the process of moving our capital city from Jakarta to Nusantara, which is a 2.5 hour flight from Jakarta to the new capital city. So that is quite an interesting, important development that is happening on the ground in Indonesia. And with that, hopefully there are ample opportunities both in the corporate sphere and maybe not so much, or hopefully maybe in the litigation and dispute sphere. Now, different with my colleagues, which I appreciate are from common law jurisdictions, Indonesia is a civil law jurisdiction. Our courts do not recognize the stare decisis principles. Our judges are not bound by court decisions or precedents that are made by previous courts. Our laws and regulations are codified in codes. So we are largely regulated by statutes, laws, and regulations, written statutes, laws, and regulations. Now, on arbitration, the principal regulation is Law 30 of 1999. We are also a New York Convention party and has been so since the 80s. Unfortunately, the Law 30 of 1999 is not a UNCITRAL model law based statute. And there's not that many developments regulatory-wise since 1999 until quite recently when our Supreme Court issued regulation regulation number 3 of 2023 in Q4 last year, which clarified and introduced some procedural requirements in relation to arbitration. Now, on the question of seed, which is the reason why we're all here today. Now, there is no prescribed definition of what seed is under Indonesian laws. And we tend to struggle and get quite frustrated when we try to explain what seed is to our non-arbitration colleagues in Indonesia. Because frankly, there is no reference to which we can point. But with that said, we could somewhat try to define what seed is, given that seed is intertwined with the powers of the courts. Now, in that regard, we can try to define what seed is based on the qualification of arbitration under the arbitration law. And in this regard, Indonesia follows a territorial approach in qualifying arbitrations. Now, under Law 30, you have a domestic, arbitration award. So there's a definition of a domestic arbitration award, and it is defined in conjunction with where the award is issued. And as you could see on the screen, awards rendered within the territory of Indonesia is considered as a domestic arbitration award, whereas an international arbitration award is an award that is rendered outside of the Republic of Indonesia. And although there is an additional qualification that aside from the location of where the award is issued, there's also a qualification that according to the laws of the Republic of Indonesia is deemed as an international arbitration award. And just on this last point though, unfortunately there is also no definition or other laws to which we can point that other than Law 30, which defines what international arbitration is. So what we're left with is really just the arbitration law, and that is based on territory. Right? But there is a court decision in 2012, which, and the judges in that case held that an award or an arbitration that was issued under the rules of the ICC, right, the International Chamber of Commerce, was considered an international arbitration award, notwithstanding the fact that the arbitration was held in Jakarta. And so under the law, by the plain language of the law, that arbitration will be considered as a domestic arbitration award because of the location of the arbitration. But the court held that because the rules itself is an arbitration rules that is of the ICC that is based in Paris, therefore the arbitration is qualified as an international arbitration one. Okay. So that was quite an interesting landmark case in the arbitration Indonesian community. Now, going back to the question of seed, and this is important because this determines the powers of the courts. And in this regard, the arbitration law provides that when there is an arbitration agreement, the courts do not have jurisdiction. And while our foreign colleagues would tend to think that Indonesian courts tend to be unpredictable, I would say that at least on this point, in the majority of cases that we handled in courts, the courts have been quite consistent in honoring arbitration agreements. And in at least 95% of the cases that we handled in courts, where one of the counterparties try to delay or derail the case by bringing a petition in the courts have, for the most part, rejected them, thus upholding these provisions that the courts do not have jurisdiction when there's an arbitration agreement in place. Now, the arbitration law, those say that the courts have powers in relation to certain matters. And what are those matters specifically? And these matters can be divided depending on the qualification of the arbitration itself. So again, the question of seed is therefore important. Now, in domestic arbitrations, essentially the courts have three powers. The first of which is in relation to appointment, dismissal, objection, replacement of arbitrators. Okay. In particular, where there is an ad hoc arbitration, when the parties cannot reach an agreement on the selection of the arbitrator, the parties can file a petition with the court to appoint the arbitrator. Right? Now, one note, however, that there is a court case that decided that where the arbitration is subject to a particular institutional rules, for instance, ICC, or in that case, the rules in question was a BANI arbitration, the court held that the court would not have jurisdiction or the power to entertain any petition for an objection in respect of the arbitrator selected in that arbitration. So the courts generally, in that case, respected that it is and deferred to the institution itself to resolve any issue regarding the appointment of arbitrator. The courts would not intervene in that regard. Now, the second power is obviously enforcement. For just a couple of notes for enforcement of domestic arbitrations, there is a provision in the law which provides that domestic arbitration awards must be registered with the court within 30 days as of the issuance of the award. 30 days might seem like a very short time frame, but it's not. It could actually be done fairly quickly. One additional note is that the obligation or the requirement that the award be registered lies with the arbitrator or the institution, the arbitration institution. So on this matter, it is important that if you were to arbitrate in an Indonesian seated arbitration, that you issue a power of attorney to the applicant that will register and enforce the award. Now that is a very, what I understand is quite a distinct feature in how international arbitration practitioners do arbitrations. It's not common. It's what I'm hearing from foreign lawyers. And the third power is in regards to annulment of arbitration awards or setting aside awards. For domestic arbitrations, the courts have the power to annul or set aside an award based on limited grounds under Article 70 of the arbitration law, which comprise if there's a fraudulent document that was used in the arbitration proceedings, and this is not uncommon in Indonesia, unfortunately. If there is an undisclosed material document that was discovered later on after the conclusion of the proceedings. And the final and third ground is if the award was issued as a result of deception by one of the parties. So the use of fraudulent deceptions is a common feature in Indonesia, I'm afraid. Now, on the flip side, for international arbitrations, Indonesian courts do not have powers except when it relates to enforcement of the international arbitration award. And just on this, the authorized court is the Central Jakarta District Court. For how long, given that we are moving our capital city, we are not sure. But for the time being, it looks like in the near future it will still be in Central Jakarta. Just a couple of notes for folks that have Indonesian contracts or who want to enforce arbitration awards in Indonesia. There are procedural requirements that must be adhered to. One of those procedural requirements is that the award must be registered with the court. The enforcing party must obtain what is called a writ of enforcement or an exequatur before the award can be enforced. Now, in this process, there is somewhat of a limited review by the courts before the courts decide whether or not it would issue the writ of enforcement. Although the law says that there should be no final review, but I suppose as human beings, the judges can't help it. And so in that regard, the judges would look to whether or not there is an arbitration agreement, whether the scope and nature of the arbitration or the dispute is commercial or trade, and whether the arbitration or the award infringes public order or public decency. And only when there are no negative or adverse findings by the courts would they then issue a writ of enforcement, and then the party could then go through the process of enforcing, for instance, foreclosing, seizure, auctioning of assets and whatnot. With that said, I leave you, before I conclude my presentation, with some tips in how to manage and select your seat wisely, and how you should what you should put in your arbitration agreements when you deal with an Indonesian counterparty or when you have an Indonesian law governed agreement. So I would just start with the seed. Your arbitration agreement, it is very recommended that it specifies what or where the seat is. And the seat is to be distinguished from the place or the venue of the arbitration. So both the seat and the venue should be clearly specified in the arbitration agreement. And hopefully my Singapore colleagues will be happy to know that Singapore is actually a very popular destination as a seat and venue for Indonesian commercial contracts. So that would be a typical choice when there is a cross-border project or transaction. In addition to that, the law of the arbitration procedure, whether this is to determine whether or not it would be subject to a particular arbitration institution or whether it is an ad hoc arbitration. BANI is, just for those who don't know, BANI is the Indonesian Arbitration Board, and it is very common for Indonesian parties to insist that if there is a institutional arbitration rules that is to be applied, then it should be the BANI rules. Although if you counter with SIEC or ICC, Singapore seated, they would more or less, more often than not, they would accept that as well. The governing law of the arbitration is also another point to be specified in your agreement. And the governing law of the arbitration is to be distinguished from the governing law of the contract. So we are starting to see more common in agreements where, for instance, where the venue and the seat is in Singapore, then the governing law of the arbitration agreement is also Singapore law. So you have an Indonesian law governing agreement, but the arbitration clause is subject to Singapore law, so that it's becoming more common. And other provisions as well, Indonesian boilerplate typical provisions such as waiver of a time period. Under Indonesian law, arbitrations must be concluded within 6 months or 180 days. So it's typical for parties to sort of waive that requirement or extend the time period. There's also a provision that arbitrators can rule on the principles or on the basis of ex aquo et bono, or I think it's analogous to natural justice, and we could waive that. And there's a bunch of other waivers and provisions that are typically handled in Indonesian law agreements that you should pay attention to and ask your Indonesian lawyers. So with that, I conclude my presentation. Hope it's useful. Thank you.
Thank you very much, Nico, for sharing your perspective from the Indonesia. I'd like to invite my final speaker, Ms. Noppramart, to share her perspective from Thailand.
Please don't leave my session until I finish, please. Only 12 minutes. Okay, why you should consider Bangkok as the seat for arbitration? Actually, you know that you come to Bangkok for shopping, touring, right? But why you consider choosing Bangkok as the seat of arbitration? I think there are so many mysterious when we have meetings with foreign counsel. Most frequent asked question, usually they don't know Thai law, Thai court, they don't know. And if I refer you back to Queen's Mary survey, you can see that I think the first thing that why people choose the seat is that the greater support from the local court, right? But the next is actually neutrality and impartiality. But you know, the first and the number one question that I always been asked by the foreign counsel that how Thai court react to the foreign party. That's really interesting. Maybe because they don't know Thai language. Maybe when they come to Thai court, no, even though yes, we speak Thai in Thai court, but we allow the interpreter for the witness parties to speak their language. But I can tell you that intellectual property and international trade court in Bangkok, we consider is the cutting edge court, the most cutting edge court in Thailand that will handle most of the arbitration cases in Thailand. The judges mostly graduated abroad. They speak Chinese, French, Japanese, English. Sometimes judges even speak English to the parties, so without the interpreter. But that is can also make sure that the party can understand each other and know the point of the issues. Come to the answer. In my experience, when I have to answer whether or not Thai court have any bias against the foreign parties, I can say from my experience that no. Actually, Thai court just like other international judges that they are neutral and impartial. So I don't think that this would be the issue. But the issue how to we establish this trust to the international user is another thing. That's why I think that THAC ADR week is something that we can inform our foreign user that, okay, now you can come to Thai court with trust that our Thai court can assist you for the arbitration process without any bias, regardless of your nationality or language. And also as I told you, many of the Thai judges right now, they graduated from abroad. They know the law. Mostly some, and also as you know that we have the Office of Judiciary that they also support the arbitrations, that train the judges, train lawyers to know about the arbitration knowledge. That can also that allows Thailand have more arbitration practitioners in our country. And come to another most frequent asked question. The third one is how Thai court efficiently handle the arbitration case. I give you from my experience that we enforce several international arbitral award. I have Barney Award enforced here successfully. Yes. We can confirm from our colleague here.
Confirm.
Yes. And that we can finish. I think that even at that time is the COVID-19, we can enforce the award successfully. I think not regarding the preparation of the case sent over, the document over Indonesia to Bangkok. I think it takes like 6 to 8 months in order to obtain the court order for enforcement of the international award in Thai court. I think it's quite quick. And what happened after that? This case will be finalized directly to the Supreme Court. For the arbitration case, we allow only 2 levels of cost. Usually we have 3 levels, but for the enforcement of the arbitration, only 2 levels of cost. So mostly the maximum time, I think usually it takes like 2 years, 2.5 years. You will get the final order for enforcement of the award. It's quite quick comparing to other countries. For the cost, sure, you come to Thailand, everything considerably reasonable price. I say not cheap, but reasonable price. Okay. Okay. For Thai court, when people ask how can we prove for the Thai court pro-arbitration, I think we have to prove from the decision. Thailand is civil law country like Indonesia, but yes, we don't have the precedent binding, right? But we can review the Supreme Court decision to see how consistent the judgment. I choose this case. Is actually the case is quite new. This case, the Supreme Court rules on the enforcement of SIAC award. I can tell you that Thailand is the top 5 user of SIAC. Congratulations, Chris. Yeah. So that, but in the side of the respondents, not the claimant. Okay. So anyway, you have to bring that award to enforce in Thailand because the respondent asset is in Thailand. Okay. Okay. So for this case, the court actually enforced the partially enforced the award. Thai court not refused to enforce the part of the compound interest. It means that for the whole thing, the principal amount, okay, fine. The court said that, okay, this okay. The court agree. Even though some part of the award is contrary to Thai law because the compound interest is not allowed under Thai law. You see, this is the great proof how Thai court confirm that, okay, this fine. We not dismiss the whole award. We partially enforce the award for you. Okay. There are several international arbitral awards in Thailand. This is another one, International Cotton Association Award. Yes, in Liverpool, right? If you are the Liverpool football fan. Okay, for this case, actually, the substance of the, I'm sorry, I have to stand, sit too long. Okay, for this case, the substance is that the respondent appeal because the court want to enforce the award. But the appellant, actually, they appeal on the merit of the case. This is another one that the court said that, oh, if you come to the merit of the case, you say that the raw cotton sale contract include invoice back, that actually impose excessive liability on the buyer. That is contrary. That is the unfair contract under the unfair contract term of Thai law, of Thailand. The court said that, no, this is the merit of the case. The court not allowed to appeal on this issue. This is another proof that Thai court actually limit the intervention of the arbitral award. I am the lawyer. I need to give you some evidence to support that, oh, Thai court pro-arbitration. I cannot just say, oh, Thai court is pro-arbitration. No. This is one of many Supreme Court judgment that you can find. But you need to translate because all the Thai judgment is in Thai. And another interesting, and I think other countries also have this mechanism, the interim measure and the preservation of the evidence by the court, by the Thai court. So even though our Thailand Arbitration Act allows that the tribunal can make the order for interim measure. However, there is the problematic when you want to enforce that interim measure, you have to go to Thai court again. But why don't you go to Thai court straight away under the Section 16 of Thailand Arbitration Act? Therefore, you don't need the tribunal to consider your application for interim order. You just go straight to Thai court. Okay? And if you want to preserve the evidence of the opposing party or the third parties, you can also obtain the order from Thai court to assist you for the arbitration proceeding. So you can see that, okay, maybe next station for the arbitration, you can consider Bangkok seat. Not only shopping seat. Nah? Okay. And I myself also act as the arbitrator. And so many times that the party asks, how can we summon the third party to be the witness? How can we obtain the evidence from the third party? Okay, this is Thai Arbitration Act allow that you can ask the tribunal to grant the order. And then I sign up the order and the party bring that order submit to Thai court. And it's very quick, even quicker than the litigation case. The court sign up and then you can deliver that summon to the person who possess the evidence or to the witness, right? So this, another one is several ex parte unilateral application that Thai court always assist in the quick response manner, proactive manner, I can say that. That if they know that, okay, this is the application in the arbitration process to stop the other side to dispose some kind of asset, something like that. Thai court can order, then the interim order, even without the inquiry from the other party. So that is quite efficient, and we can say that this is a great support from Thai court for arbitration. Okay, for Thai court, I told you that Thai court really limit the judicial intervention. For this Supreme Court case is the last year judgment. 2566 is actually Buddhist year. We not use like Christian year, so okay, 543 years different. Okay, for this case, the arbitral tribunal rules that for the special offer price constitute uncompleted completed sale under Civil and Commercial Code did not violate the section 152. And in this case, the lower court actually not the lower court decision to void the contract challenged the tribunal discretion in interpreting the party intent. In this case, the Supreme Court disagreed. The lower court's partial setting aside of the respondent ownership. In this case, it is the Supreme Court think that the lower court decision is interfere the tribunal decision. The tribunal think that the respondent ownership should not be void, but in this case, the Supreme Court said that, oh, lower court, you cannot make the review of the merit of the case. You have to follow what the tribunal already made the decision. So in this case, it's proof that the Thai court not try to interfere with the merit of the case. So that all I think that I want to share with you in terms of Thailand perspective. In case that you have the award to be enforced in Thailand, think about these issues. And also, I think that I cannot confirm that all the arbitral award can be enforced in Thai court because it depends. If the case is related to the public policy and contrary to Thai law, yes, Thai court would dismiss and not enforce your arbitral award. But if the award is seated in Thailand, Thai court can set aside that award that contrary to Thai law. So, but anyway, I think that I give you some information, at least to show you some evidence that Thai court actually support the arbitration. Even though we speak Thai, but I think that right now we speak arbitration language. Okay, so I hope you enjoy these seminars in both first and second, and we also host you the lunch, and please feel free to take the lunch outside, and we can have this room until 2 p.m. And I hope that we can come back to Tilleke and Gibbins again. Thank you very much, and thank you THAC for hosting this event.
Thank you very much, Noppramart. Now, before we go for lunch, we would like to open to the floor for questions. Does anybody have any questions, please? And I can pass you the microphone.
I have a microphone.
Please go ahead.
Thank you. I'm Joseph from Tilleke and Gibbins, and thank you for your good presentations from all speakers, especially Kun Joseph. And one of several factors in Thailand before we choose the arbitration institution is the cost. So apart from your presentation, can you share or idea the estimate arbitration fee or cost from the beginning until the arbitrator issue the award in your jurisdictions? How much that is cost? Thank you.
Okay, who would like to take that question?
Maybe I start from the perspective of Singapore. That's actually a very difficult question to answer. Because the fees, the SIAC, for example, and what the tribunal charge, that we have visibility because there's a scale, depending on the quantum and the size of your claims and counterclaims. Now, legal fees, unfortunately, it sounds like the market, but it can be the sky, it can be the ground as well. And it will largely depend on the size of the dispute, the type of law firm that you want to appoint, and how long the process will take, for example, and what the issues in dispute are. I would say generally, if you are looking at, say, a claim value of 10 million, for example, I think you would expect to spend, assuming it's not an overly complicated claim, maybe about 10% of what the claim amount is. But that's a rough gauge because it really depends on the law firm that you choose, and some are more expensive than the others. Yeah, but Drew and Napier is not the most expensive. Joseph?
I really can't echo more than what Chris has said. Legal fees is always a very sensitive topic to talk about. But yes, I would say that's roughly the sort of position in Hong Kong as well. Although, I mean, if a lot of users, for example, from mainland China would say that Hong Kong legal fees are on the high side, but if you compare with some places, for example, the US, I would say we are quite modest. So is my firm, Deacons, very modest.
Nico?
Yeah, I suppose for Indonesia, compared to colleagues from Singapore and Hong Kong, we're very modest. Right, so just a rough idea. What we are doing a $150 million arbitration at the moment, and it is a Bani arbitration. And the Bani fee is like the SIAC has a scale. And for a $150 million arbitration, the arbitration fees that goes to the institution and the arbitrators is around $1 million. So that's only for the administration of the arbitration. And obviously when you go to Bani and this sort of arbitration institution, you get the whole package. They administer arbitration for you. But that excludes the lawyer fees. And what I would say to that is just come to us and we provide a proposal. Yeah. Thank you.
Thank you. Noppramart?
I think we charge reasonable price. So the most reasonable price. But I think it's depend. It's depend. Sometimes it's not depend. It's not about the claim amount, but it's the nature of the case that maybe the claim is not the big claim, but it's quite complex. That is sometimes it's quite challenging how we quote this kind of lawyer fee. But another thing, I think that client may also consider when you choose the arbitration institute, when you insert the arbitration clause, you may need to check first that which institute that maybe provide the cost that is suitable to your business. Sometimes I found some case like that. It's like ice cream producer, but you choose ICC that you go to Paris. It's nonsense. So I think that it depends. First, you have to start to choose the institute that suits you first, and then you choose the law firm, the lawyers, right? So I think that is quite basic. Yeah.
Thank you, Noppramart. Do we have any more questions? Yes, you have a question? Okay, since there are no more questions, we can now adjourn for lunch. Thank you everyone for your patience. Bye-bye.